At some point in a serious lateral conversation, someone is going to ask you for a list, a client list, a representation of your book, a document that translates your practice into something concrete that a recruiter can work with and a prospective firm can evaluate. And right here is where a lot of lateral conversations, even ones involving excellent attorneys with strong practices, go wrong. Not because of anything dramatic, because of preparation, or more accurately, the lack of it. I'm Andrew Wilcox, legal recruiter since 2003. Today, I want to talk about something that sounds administrative, but is actually substantive: how to prepare a clean, ethical, professionally appropriate client list before you engage seriously with any recruiter or firm, and why doing this right, doing it carefully and thoughtfully, is not just a practical concern, but a professional one. Let's start with the ethical dimension first, because it comes first. Attorneys have professional obligations that don't pause because they're thinking about a job change. The information you share about clients, who they are, what they do, what matters you've handled for them, is subject to your duty of confidentiality. That duty exists regardless of whether the attorney client relationship is active. It exists regardless of how general the information seems. And it exists regardless of how much you trust the recruiter that you're talking to. This doesn't mean you can't share any information about your practice. It means you need to be thoughtful about what you share, how much detail you include, and what can be shared at which stage of the conversation. The general practice in legal recruiting context is to share client names and general matter descriptions in a way that allows a conflicts check and a general understanding of your practice without sharing confidential client information. The identity of a client, that you represent them, is generally not itself confidential, particularly when the representation is publicly known. The substance of the matters you've handled, the strategy, the specific facts, that's obviously where you need to be careful. When in doubt, talk to a professional responsibility resource before you share anything you're uncertain about. This is not a moment to improvise. Now, the practical dimension. What makes it a client list actually useful? The client list that is useful in lateral conversation is not a dump of your billing system. It's a curated, organized document that presents your practice in a way that is both honest and compelling. Those two things are not in tension. An honest presentation of a strong practice is a compelling one. Here's what the document should include. For each significant client, the name of the client, the industry or sector they're in, the general nature of the representation, transactional, litigation, regulatory, advisory, and your role in that representation. Are you the originating attorney, the lead attorney, one of several partners serving the client? That distinction matters enormously, and you should be very explicit about it. Include any approximate sense of the revenue, either the annual billings or the total matter value, at whatever level of specificity you're comfortable with, given your confidentiality analysis. You don't need an exact number, but prospective firms need some sort of sense of scale. Note the duration of the relationship. How long you've been representing this client. A 3-year relationship has a different texture than a 12-year relationship. And note the nature of the legal work, the substantive areas, the complexity level, the profile of the matters. This is where the sophistication and distinction of your practice comes through. Now, what to leave out and why? Leave out matters where the representation is genuinely confidential in ways that make even the client's identity sensitive, where disclosure would itself be a breach. When in doubt about a specific matter, leave it out or describe it in anonymous terms, a major financial institution rather than the institution's name. Leave out matters where you were a junior participant with no meaningful client relationship, staffing assignments from years ago, matters where another partner controlled the client entirely and you were purely a service attorney. Including those doesn't strengthen your list. It dilutes it and creates a false picture of the book's portability. And leave out clients whose business you cannot realistically expect to control in any way. If you include institutionalized clients that are obviously the firm's, not yours, an experienced recruiter or firm will notice, and it will raise questions about your judgment and your self assessment. Now, the organizational structure that works. Organize the list by category of client or matter type, not just alphabetically. Grouping your clients by industry or practice area helps the reader understand the coherence of your practice and the depth of your experience in particular sectors. It also makes the conflicts check much more manageable. Put your best, most portable relationships at the top. The clients you originated, that you've had for years, that reflect your most sophisticated and most distinctive work, those go first. That's where the reader's attention is strongest. And the timing of the disclosure. Share general practice information with a recruiter early. Broad category, approximate size, nature of the work. This is enough to have a productive initial conversation and to make sure the recruiter understands your practice. Share a more specific list with names and reasonable detail only when you've established a real level of trust with the recruiter. When the conversation has moved to a point where specific firm candidates are being considered, and ideally when you've been assured about how the information will be protected, share the most detailed version. The maximum specificity about clients, matters, and revenues, only in the context of a formal exploration with a specific firm at a stage where they are conducting a serious conflicts analysis and making a real evaluation of your candidacy. Why this matters is beyond obvious. Attorneys who present their practice with clarity, precision, and evident thought about the ethical dimensions of disclosure do something important. They demonstrate to the recruiter and the prospective firm that they approach professional obligations seriously. That is itself a signal about the kind of partner they'll be. Preparation signals professionalism, and in a lateral conversation, professionalism is never wasted. I'm Andrew Wilcox. This is the Lateral Brief. If you'd like to have a confidential discussion about your practice area or your career goals, please email me at andrew@wilcox-legal.com. As always, grateful, Andrew Wilcox.